29 years, I was a solicitor in private practice, and for about 16 of those, I was the founding partner in a firm of solicitors in South London, dealing with leasehold law. But since the 1st of October, I have been appointed the regional judge of the First-Tier Tribunal Property Chamber, the division of which I head is the residential property part, the Residential Property Tribunal. Now, many of you will be familiar with the Leasehold Valuation Tribunal, the LVT, Rent Assessment Committees, Residential Property Tribunals. They were all abolished in England, not Wales, with effect from the 30th of June this year. And all of their jurisdictions, in particular in relation to service charges, appointment of managers, the right to manage, were all taken over by the Property Chamber with effect from the 1st of July. Now, in the Property Chamber there were three divisions, but residential property, if you like the old LVT, is by far and away the biggest division. And apart from the change of name, the other single most big change is the new procedure rules. We had three different sets of rules, one for the LVT, one for the Rent Assessment Committees, and one for the Residential Property Tribunal, and they have now all been merged into one unified so I'll use the laptop. One unified set of proceedings, which are the Tribunal Procedure, First-Tier Tribunal, Property Chamber Rules 2013. And if you Google Tribunal Procedure, Property Chamber Rules, you'll immediately come up with a file that you can download or print with the new rules in them. Now, these rules were 2 years in the making, and the opportunity was taken to rationalise the existing rules. So there hasn't been that much change, though I am going to highlight a few in a minute. But what we did change a lot was that there is now a greater flexibility in case management. And one of the criticisms of the old rules was that when people didn't comply with the rules, there was very little the old LVT could do about it. And that used to upset a lot of people, including tribunal members. But now we have much stronger powers to enforce our own directions in the tribunal. So this slide shows the issues that I'm going to deal with, some of which have already been raised in questions earlier. I hope that I will leave time for your questions at the end, so if anything that I say is of interest, or if you want to continue some of the things that were said earlier, then I hope there's time to deal with those. So the first thing to know is that we have a new overriding objective of the new rules, and our overriding objective in whatever we do as a tribunal is to deal with cases justly and fairly. Now, Rule 3 of the new rules sets out what that includes. It's not an exclusive, exhaustive list, but it means that we should avoid unnecessary formality, that we should avoid delay, and that we should act proportionately in relation to the importance of the case or the complexity of the issues or the value, and importantly, proportionately to the resources of the tribunal itself. And in addition, as it were, the flip side is that there is a duty on all parties before the tribunal to help us with that overriding objective, to help us decide cases fairly and justly. And there's a duty on parties to cooperate with the tribunal. Now, we take that overriding objective very, very seriously. So if you are involved in a case with the tribunal and you write in wanting us to do something because you think maybe the other side is acting unfairly, or you think that something could be achieved more quickly or more efficiently, whatever, then you should refer to the overriding objective. Because we read the letters, and if you mention that you think that what you propose will further the overriding objective to deal with your particular case fairly and justly, we will take that into account. So it's a serious thing. The other thing to bear in mind for those of you that live or have properties in London is that the London region operates a free mediation service. So if you are involved in a case, we have trained mediators who are able to take up your case and conduct mediation between you and your opponent, provided the other side agrees. It's a free service, it's entirely confidential and voluntary, and we have a success rate currently running at about 66 to 67%, though it has been as high as 75%. So if you are involved in a case, please consider the free London mediation service. So what are our new powers? When you're involved in a case, you'll want to look at Rule 6, which are our general powers, and they are very broad indeed. And an indicative list is given in Rule 6 as to the sort of things that we can do. We can regulate our own procedure. That means we can do things however we want to do them. We can make specific orders to get the case to a hearing quickly. We can extend time or shorten time. If we put a time limit, we can change it. And if there's a failure to comply by one or other or both parties, then we can deal with it. So pretty much we can do anything we want. And that is a new power, it's much broader, and that is going to be the single most biggest change that you will notice as users of the tribunal. If you're involved in a case and you want something done differently to the ordinary course of events, all you have to do is write in and explain why, and you can make reference to our powers in Rule 6, and if you can, expressly by reference to one of the points in Rule 6. I'm not saying that we will agree to what you suggest, but we will certainly take it seriously and look at it. Rule 7 tells you how you can make an application, whatever it is. And it is supplemented by a practice direction that gives details of how applications are made. And you can find the practice direction on the Justice website, that's the government website. And again, if you use Google, if you just Google practice direction property chamber, it will come straight up at the top of the search. So it's readily available. Now what happens if the other side, or maybe you, fail to comply with a direction? The tribunal can take such action as it thinks fit. It's pretty amazing, isn't it? We can do what we like in relation to that failure to comply. But in practice, what it entails is what's set out in Rule 9, which is the striking out and barring. And this is our ultimate sanction if people do not comply with orders. If it's an applicant that's not complying, we can give them a direction and say, well, you must do this. For example, if I give you an example, if there's no disclosure of documents, we can say you must disclose a document. And if the party doesn't disclose the document, then we could strike out the application in a very serious case. Now that's not something that we're going to do a lot of, because you can imagine that taking such a serious step can result in further litigation trying to reverse what we've done. And there is a power in certain circumstances to reinstate cases which have been struck out. But it's there, and it's something that is completely new since the 1st of July. If, on the other hand, you are a respondent, that means the application has been brought against you, well, we can't strike out respondents, but we can debar them, we can prevent them from taking part in all or part of the proceedings. So it works both ways. Both sides, there are sanctions. I should point out that if an applicant doesn't pay a fee when required to do so, then their case is effectively struck out because there's a deemed withdrawal. So it's very important, if you're bringing a claim and you don't benefit from a fee waiver, if your finances are such that you qualify for a fee waiver. If you have to pay a fee and you don't do so, then your case will be deemed withdrawn. So it's important to meet time limits and to respond to letters. And once again, in certain circumstances, there is the power to apply to reinstate a case that has been deemed withdrawn. Orders for costs. Now, this is obviously a great worry to many people. The tribunal is a no-costs jurisdiction. That means that at the end of the case, we don't make orders for costs against the losing party. And that is a big difference between the tribunal and the court. In the court, the loser pays the costs. But in the tribunal, we don't make any such order. There are powers to award costs in exceptional circumstances. One of them is wasted costs. That's where you engage a lawyer and the lawyer has been negligent or inefficient or has caused problems. We can make the lawyer pay costs in those circumstances. That's wasted costs. And the other situation is where a party has acted unreasonably. This is the similar provision. It's slightly wider, but it's similar to the old £500 rule, where if a party acted vexatiously or frivolously or otherwise unreasonably, we could award up to £500 costs against them. So this is slightly wider, and the aspect that causes greatest concern is there is now no longer any limit on the costs that we can award. So the £500 is gone. But bear in mind, it is only in this situation where somebody is acting unreasonably in bringing, defending, or conducting the proceedings. If you act reasonably, then there's no risk of an award of costs. Now, there are other ways that landlords can get costs out of leaseholders which have nothing to do with the tribunal. One of them is through the county court. As I said, the county court can award costs. Another way is sometimes there are provisions in leases that allow landlords to get their costs back from leaseholders. But that's a matter for you to look at your lease to see what provision is in there.
Schedule 11 here in front of your tribunal, with great respect.
Schedule 11.
That's what happens when the landlord goes to administration charges,
Yes.
and then comes back to another LBT, as
Yeah.
in my case,
Yeah.
and you get clobbered with £44,000 of costs through the LBT or the property chamber.
The tribunal, I'm not being disingenuous, the tribunal has the power to decide that any costs that a landlord charges a leaseholder through the lease, as an administration charge, as was mentioned over there, whether or not it's reasonable and payable under the lease. So there is power to decide whether the costs are payable, but that is different to the tribunal making an award of costs, which we don't do. It's a different concept, and it's important to remember that. Rent cases, some of you may be involved in rents, whether as tenants or landlords, the setting of fair rents or market rents. There are no costs at all in rent cases. So disclosure, experts and the like. We have a very wide discretion as to what we can order. I think the best thing to say to you as parties or potential parties to a case is that if you think you need a document from the other side, or if you think you need an expert, or if you think you want to call a witness and get a witness summons, do so early. Don't leave it to the last minute. Do so early. Very often, parties will know what documents they want to see from the other side. Produce your list and send it into the tribunal with an explanation. This is what you want and why. We will ask the other side what they have to say about it. And for all we know, the other side will agree. Experts. Generally, experts give their evidence in a written report, and that's usually sufficient. But you do need permission to bring an expert, because very often we don't consider that they are necessary, whereas parties consider they're absolutely vital. So if there's a divergence of opinion, set out your case. Why is it you need an expert, but more importantly, what is it that expert will say? So far as witness summonses are concerned, this is also completely new for our tribunal, and in London at least we've never issued one. This is to force somebody to come to the tribunal hearing, either to give evidence or to produce documents. What the rule says is that you have to give any such witness 14 days notice before the hearing. If you're considering a witness summons in any case, please don't leave it to 15 days before the hearing, because there just won't be time. Now we have power to extend or reduce time, so that might be a possibility. But do it early, don't leave it to the end of the day. Another big change to the previous practice is that if a party wants to withdraw their case, as happens sometimes, you need the tribunal's consent to do that. Now you might think that's a bit strange, but we sometimes have cases where there's been 5 or 6 months of litigation, and it comes to within a day or two of the hearing, and one party just pulls out like that, or tries to pull out, leaving the other party stranded, having incurred lots of costs, a lot of time and effort, but they've withdrawn, case is all over. Now that can't happen just like that. Whoever is withdrawing a case needs our consent first. If a party is going to withdraw their case, they should tell the other side. And if you receive notice that a case is to be withdrawn and you don't agree, then you need to get in fast with your letter, email or fax to the tribunal saying what you think should happen, either that you oppose it or that you think conditions should be placed on the withdrawal. But you do need to act quickly, because if you've been notified and we hear nothing and we can't see anything wrong with withdrawing, we'll give our consent to it. Hearings are generally public. Any one of you could go tomorrow and sit at the back of one of our tribunal hearings if you want to see what they're like. In London, we're about a 10-minute walk from here in Alfred Place near Tottenham Court Road, and you're more than welcome to come and have a look. If you're involved in a case, it may be worthwhile coming one morning at 10 a.m. and asking to sit at the back of any hearing, just to see what it's like, to get a feel of what we do. We can make consent orders, which is a new feature of the rules. At the end of your case, as before, you will get a written decision, and we have target times of 3 weeks in rent cases and 6 weeks in any other case for a written decision. Sometimes it's beyond that, but very often it's much more quickly. It's done much more quickly. Let's stop now. Okay, well, I've just been asked to stop, so this is actually my last slide, so if I could just spend 1 minute on appeals and reviews. Sometimes we can set aside a decision that's been made if there's a procedural irregularity. So if you've sent in documents and we didn't get them, we might set aside the decision that's been made. All appeals go to the upper tribunal, Lands Chamber, from now. And we have the power, which again is completely new, that if you apply for permission to appeal, we can review your decision. And if we think, on your explanation, that we might have made a mistake, we can reopen the decision and remake it without your having to go up on appeal. So that should save time. So the only other thing to say is the fees that were there have gone up by inflation. There is consultation to increase them further, but that's nothing to do with the tribunal. So I'm happy to take questions.
Well,
or would
I
you
think
like
I'm
me
going to
completely
have to
stop?
move on through my agenda because of the way. But if you are around for a few minutes, I'm sure Peter might be able to come up and talk to you.
Okay.
Thank you very much indeed.
All right.
So,
well, thanks very much.